From the McCourtney Institute for Democracy at Penn State University, I'm Chris Beam.
I'm Candace Watt-Smith.
I'm Jenna Spinelli, and welcome to Democracy Works. This week we are talking about juries, and our guest is Sonali Chakravarti, who is a professor of government at Wesleyan University and author of the book Radical Enfranchisement in the Jury Room and Public Life. You know, we talk a lot on this show about voting as a civic duty. And, Sonali argues in her book and in this interview that jury service is right up there with it as something that should be taken seriously and really thought about as an integral part of our democratic lives.
Well, that's right. But it's not, I mean, she is not talking about jury service as a duty merely. She's talking about it as a form of democratic empowerment. This is a role that citizens have that is dramatically democratic insofar as we are giving 12 citizens the responsibility and the right to determine, what is going to be the consequence of a civil or criminal trial. And she is absolutely right to say that we don't say enough about that as part of our, birthright as citizens of a democracy, to have that power and to be able to express our will in that way. And we don't do it nearly as often, but when we do it, it is far more substantive and it's far more important than voting.
So I really appreciate that. Really, also just kind of the articulation of serving on a jury and being able to serve on the jury as maybe the kind of other side of the franchise. And I guess, she helped me to connect a dot that I think I had both of the dots there, but hadn't fully connected them. Insofar as, in most places, the way that you become a juror or get into the jury pool is being a registered voter. And so, that's more of a technicality. And the fact of the matter is that it doesn't have to be that way, right? That there are other ways to find out who are eligible jurors, but and it is often the case that it is linked with voting.
And I when we were reading this, I was recalling when E.J. Dionne and Miles Rappaport were on the show. They recounted that during the civil rights era, far from seeing jury duty as a pain, something that they wanted desperately to get out of, the African Americans in the South demanded the right to serve on juries. And the reasons for that are obvious, but it is if it's part of enfranchisement for citizens, then it is absolutely imperative that everyone have that opportunity, right? And then that leads to a whole variety of questions about the fact that so few trials go to juries. The fact that literally like 3%, 2.5%. It's virtually none. And then you talk about the process by which juries are selected, not just into the pool, but then from there on out. There's all kinds of ways in which these questions of control come up, and then also how do they advance or compromise the democratic dimension of jury duty.
I think the other thing that is important to consider is this idea that, okay, we don't want to, people on average do not want to serve on juries, but there also is a suspicion that the people on the jury are not capable of doing their job really well either. And what I think that kind of tells us is about the health of democracy too. So, right. So one, the kind of the extent to which people want to constrain access to the jury is a signal of the health of democracy. And I think also the extent to which we believe our fellow citizens are capable of making excellent decisions in this space, right? Do we trust them? Do we think they're capable of doing that work in a non-biased way? I think also tells us a little bit about where we are in our kind of civic relationship to one another.
Have either of you ever served on a jury? I know I've never even been called for the initial round.
Yeah, I have. I was actually foreman, and it was it was an incredible responsibility. I was worried, scared to death that we were not going to make the right decision, that we were going to make the wrong decision. And either way, right? Either way, this is terrible. This would have been terrible if if the person was guilty and we found them innocent. That would have been terrible, and far worse if they were innocent. We found them guilty, and it was challenging because it was bringing together people who were vastly different in terms of their background and education and everything, profession, everything else. But I feel like we did it right. It was we did the right thing. And the first thing when I got out was I asked the person who was the officer who was our kind of a liaison. I said, "Did he have any priors?" And he said, "No." I'm like, "Okay, good." Anyway, so yeah, we found him innocent.
So, Chris, do you feel like that process made you feel more confident about that system or less confident?
This is not the answer you want, but I'd say both. I feel like there is that lawyers are very good at manipulating juries, and they do it in a variety of ways, subtle and not so subtle. That manipulation extends to the construction of a jury. It's their job to win the case, and so it's their job to work the jury in a way that is built more on rhetoric than it is on a cold and deliberate accounting of the facts. But on the other hand, I would also say that we all took the responsibility of being in that room very seriously. And we were not about, and I said, we're not leaving until everyone is able to go home and sleep well tonight. And so we did. We stayed and we just worked it through. And that's, I think as long as you have that, and that's the job, I think, of the judge, right? And he was in this case, was very deliberate about his mandates to us and what we should be looking for and how we should be examining the law. And so I think, in most case, as is true in most cases, the person who has ultimate authority is going to be the one who sets the tone. And if the tone is set correctly, then it's likely to be a good experience.
Thank you for sharing that, Chris. It's interesting to think about your specific example in the context of the broader themes that Sonali draws in her book and in the interview. So without any further ado, let's get to it. Here's the interview. Sonali Chakravarti, welcome to Democracy Works. Thanks for joining us today.
I'm happy to be here.
So much to talk about in your work on juries and the notion of radical enfranchisement that you write about in your most recent book. But I'd like to start maybe with a little bit of history about how and why we have juries in America in the first place. As I was reading your book, I was thinking about some of the ways that the idea of a jury, it kind of runs counter to what we hear about the founders and their skepticism of direct democracy and giving too much power to people who are not elites, and also to the idea of liberalism that, we should vest authority in institutions and experts. So juries are kind of the opposite of both of those things. I wonder if you could just talk a bit about, how and why they came to being in this country.
Yeah, thank you for that question, because I think you're right that juries do push against so many of the other things that we think protect democracy. And I think that's another reason why supporters of juries often come from across the political spectrum. Sometimes you get strange bedfellows when you write about juries. But to your question about how juries started, one history traces the jury back to the Magna Carta, and in that document there was provision that anybody who was tried before the king had to be tried by a jury of peers. And at that point, what peers meant were elites and barons, people who we wouldn't think of as ordinary people. But it's still significant because there was this understanding, even in that document, that the king can't have total control of the procedure. That for a procedure to be legitimate, to be following rules other than brute force, there has to be some type of check against arbitrary power. And having a jury is a very important way to do that. It's a way to tie the hands of the sovereign so that the rule of law can be paramount. And the founders also understood this, and juries were really important in the colonial period when those in the colonies didn't think that the law of England should be applied in the same way or wasn't relevant. There is the famous libel trial of John Paul Zenger, where a jury found the defendant not guilty for libel because what this newspaper editor had published was true, and they didn't feel that the defendant should be published for libel if the information was true, and they went against what the stated law was. And that was an important case that showed the independence of the jury, how important it is for a local community to decide not only is this a law and is there evidence showing that someone broke the law, but do we want to punish this person at this moment? And that idea of local control over punishment, that kind of final stage when before the state can become involved in taking away one's liberties, was something that was very important for the founders to continue. And so they built the right to jury trial into the 6th and 7th Amendments of the Constitution for criminal trials and for civil trials. And there was this sense that even though we're breaking away from a monarchy, we still think that despotic authoritarian power could be a problem. It could be a problem with the democratically elected leaders. It could be a problem with prosecutors. And the jury is one way to stop that from happening.
And I think that sets us up nicely for your concept of radical enfranchisement. Not just that juries can come together and address the question at hand, a la 12 Angry Men or any other conception of juries in popular media. You argue that juries can actually perhaps expand the bounds of democracy, or build even more on this idea of the power that we have as democratic citizens.
Right. When you hear the term enfranchisement, people think automatically of voting, and that's the pinnacle of being a citizen. And if you're enfranchised, you know about your right to vote and you use it. And I think that's true. It's a very important one and is the key to democratic representation. But the other half of enfranchisement is the right to serve on a jury. And I write about that because I think it's the most demanding obligation we have. And if you think about when you're a voter, you have to think about what your preferences are and express them. Like being a juror means you're not just thinking about your own preferences. You're thinking you're making a decision that affects someone else's life, and you have to do it through a discussion and persuasion and deliberation with other people. So just what it means to be a juror requires so much more in terms of civic knowledge, in terms of knowledge about the human psyche, in terms of knowledge about how to engage with other people, how to communicate. And so it's just a really robust understanding of what it means to be a citizen. And the kind of the flip side of that is that when you serve as a juror, people, see that like if the state trusts me to make this decision, like I'm, must be, someone worthy of this. And so it has this ennobling effect, I think, of being told that, yeah, we have lots of lawyers, who know the law, but it's you 12 people we trust to make a decision about someone else's fate. Yeah. And I think the combination of the kind of the intensity of the task and the feeling that the jurors have leads to a different relationship to the law after jury service, and that's where the kind of the radical part of radical enfranchisement comes out. In that, once you're a juror, you see that actually democracy needs me and to participate in it to work.
As I was reading your book, I couldn't help but think about Desmond Meade from the Florida Rights Restoration Coalition. We've had him on the show before. He's really worked to get voting rights and civil rights restored for formerly incarcerated people, and that's one group in some places that formerly incarcerated felons. It's one group in some places that does not have the right to serve on a jury. And so we also know about, in the Jim Crow era, African Americans were excluded in a variety of ways from serving on juries. And so we've had so much attention and so much progress about voting rights and, that side of enfranchisement that you were talking about before. I wonder where we are comparatively with the right to serve on a jury. Are we at the point where juries really are truly representative of our democracy as it stands today?
Yeah, and the answer to that is no. Juries fall woefully short of the representative ideals that we would like to see in juries. And the move to allow formerly incarcerated people to serve as jurors, I think, is a really good one. And I think, and in some ways, is a kind of a limit case, because if we can work on that and think about what that means, hopefully many other people will also be allowed to serve. But what we know is that people of color don't serve on juries at the same rate, and that especially in cases where there are Black defendants, and we know that across the country there are many trials that there is not a single Black juror for that case, and that this is a huge problem. That going back to the idea that what we want from jurors are knowledge of the community in which the crime took place and knowledge of how the law is enforced. And so if we have such racial disparities on juries, can we really say that it is a fair trial? And so I think there are a couple of things we can do to improve racial representation on juries. One is to get better lists that we draw jury names from. So right now, many states use what are called, motor voter lists. So they look at lists of people who have driver's licenses and lists of people who register to vote, and you could be on both lists, and then they, pull randomly from that collection of names. And so that is good at picking up certain people, but it is not good at picking up possible jurors from people who might change addresses a lot, who don't have a driver's license, who might not have registered to vote, but are citizens. To be a juror, you need to be 18 years old and a citizen, and you also need to be comfortable with English as the language of the courtroom. So one, possibility is for states to follow what Massachusetts does, which it has residency lists that are updated yearly about who actually lives in this town at this year. So that would be better because it picks up renters and other people. Another thing to do is to use a kind of tax records and to see who paid taxes in this area in the past year, and use that as the list. So that's one way to get more representation into the larger pool. And the last thing I'll say about this is that I think another way to create more racially diverse juries is similar to what we saw in the Chauvin trial in 2021. So I've written about how the judge set up a culture of trying to create an inclusive jury in that trial. And it's a very unusual case. It was watched around the world, right? Because it was about the death of George Floyd and the national and international movement for Black Lives Matter that it set into place. So the judge knew that, like, we need a racially diverse jury for this, so that an all-white jury is not going to be seen as a legitimate jury in this case. And I think attorneys on both sides also knew that, like, it doesn't make sense to pick off all the jurors of color. And so a couple of good things happened during the voir dire selection for that case. One was they got a lot of diverse jurors in the larger pool. Other scholars have commented on, like, how many young people were showed up to jury duty that day, and so they kind of got a good list, or they also, that the way the Minnesota state court system works, was able to draw a good pool of jurors. Good meaning diverse in a couple of different axes. Then the second thing that I think the judge did during that trial that was good was he really encouraged all jurors to speak very candidly about their reactions to the death of George Floyd and what happened in its aftermath. And so you had jurors saying, like, I can't believe, another person died this way, or this, this is connected to different types of racism that we have in our society. So really candid, open statements about what happened at that time. And the judge wanted to make sure that these jurors could also be fair to the defendant, Derek Chauvin. So he asked several questions about that, and about whether the juror could follow the procedure of the trial, including the defendant's right to remain silent, the fact that the burden of proof was on the prosecution. So the judge didn't say that, like, anybody who, regardless of how they feel about Chauvin, can get onto this trial. But what I really appreciated was the judge held both things in a delicate balance. That you could have very strong feelings about George Floyd's death, but you could also be willing to follow the procedures of the court, and you understand why Derek Chauvin deserves a fair trial.
If I think back to my own family and people that I know who have been called to serve on a jury, their attitude is almost always, well, what can I do to get out of this, right? What excuse can I come up with? What can I say? Whether it's like before you even get to the courthouse or during the process, to like try to not do this under any circumstances. Does that match up with broader public opinion about how people feel on serving on juries?
I always feel like my job is to get people excited to serve on juries, and that's how I determine whether I've been successful with my students. Is like, will they say yes to jury duty? But no, that is the feeling, and there's that kind of the old kind of chestnut is like, I'd never want to be judged by 12 people who were not smart enough to get out of jury duty. So in that, there's both what you were saying, which is like, it's such a drag. Like, who really wants to have to go and sit there for that many days? But also this cynicism about fellow citizens, right? The sense of like, I don't trust my neighbors really with any important decisions, or like I'm smarter than everybody else, and so one reason I study juries is because they're a microcosm of democracy, and it's like the problems we have with juries are the problems we have with democratic life. And if you think your fellow citizens are too stupid to judge your case, then like that is a crisis for democracy. Like we should be addressing that more broadly. But as I said, that scholars who've done questionnaires with jurors after they've served find the opposite. That they actually are glad that they did it. They were impressed by many of their fellow jurors, and pleasantly surprised by how seriously people took it. So I feel like that should also be part of the education around it. That it's not just the kind of nuts and bolts of what it means to be a juror, but actually what people get out of it that is unexpected. And I think this could also have consequences for how many people take their cases to jury. Right now, just a tiny fraction of cases go to jury. The rest are settled by plea bargaining in the criminal system, and other means in the civil system. And I think part of that is people are like, I don't trust juries, or you never know what's going to happen in a jury, or the jurors aren't going to be like me. So I think if more people wanted to serve on juries, we actually might get more defendants choosing to go go that route. I think another thing to do to facilitate that would be to make trials shorter. I know some courts are trying to have like 3-day trials or set time limits, because that both keeps down costs, but also makes it more appealing for jurors who have to pay attention for that amount of time. So I think changing the way we think about juries has an outsized impact on the legal system more broadly.
Yeah, and I think that in a way brings us back around to the idea of jury nullification that you mentioned earlier. And I know you wrote last year about how that might be used to protect reproductive rights in kind of the post-Roe era. So can you set that up for us and explain, maybe using this issue to explain how nullification works and how it ties to the notion of radical enfranchisement?
Yeah, so when jury nullification is a power that juries have to give a not guilty verdict without being overturned by the judge, who might say, "Oh, look, but I thought the evidence was compelling." Juries always have a right to say not guilty, and this is the kind of core of their independence, right? If we thought that other people would say that jury made a mistake, it should be guilty, then that would really gut the whole system of the power of the jury to act as a check on the inappropriate enforcement of punishment. And juries can decide not guilty either because the evidence is not there, and that's kind of a straightforward way to do it, or they can decide that the law itself is unjust, or that it's being applied in an unjust way here, or that the prosecution was corrupt somehow in how it presented the evidence. So these are all, legitimate reasons for a jury to return a not guilty verdict. And we call it a nullification when we think that it is one of the reasons that is apart from the evidence. So it was something to do with the law itself or its application. And juries have always had this power, and it's recognized by the Supreme Court. Though the court in this country has said that the jurors don't need to be informed of this, of their power, that in some ways it is kind of intrinsic and organic to what they're doing. If they don't feel like rendering a guilty verdict, they're allowed to do that. But no one needs to tell them that there's this thing called jury nullification and that it has this history. Some of the times in American history where we've seen nullification, for example, during the Vietnam War, where the defendants might have been protesting the war and destroyed property, in the context of that, are times when America is really divided about the law, or there's multiple legal regimes coexisting in one nation. And that's during the time of the Fugitive Slave Act was another time where we did have a national law saying that if you help a slave escape, you could be punished with a fine and prison time. But there were many people in the North, especially, that did not agree with that. So I think we're in another moment where we do have competing legal regimes. And so I think that for those of us who think that there may be people in states who don't agree with what their legislatures have done in terms of criminalizing abortion, that they should know that if they are called to be on a jury and they're deciding whether to punish someone who has assisted a woman with an abortion, they could think about nullification and this idea that even though the law on the book says you're not allowed to do it, do they want to punish this person for that act? And I think that for this nullification idea to kind of take hold, we need to have more open conversations about why we have nullification and then how it could be misused. And because I think with a not guilty verdict, like someone is harmed by that potentially, and jurors need to think about that. And then they also need to think about if they had a guilty verdict, what would that mean and what would that say? So I think this is a really important time for different social movements, including those in support of reproductive rights, to think about cases where abortion is criminalized and what jurors might do in those cases.
So as we wrap up here, you and I were chatting before we started recording about our mutual colleague, John Gastel here at Penn State, who studies ways that juries are used outside of the criminal justice system to make decisions about other things in our public lives. And so I wonder how you think about that. Like, can some of the, citizen juries about, I don't know, budgeting or big community level decisions, the things that John and others study, does that tie back at all to jury applications, specifically within the legal system that you study?
Yeah, I get asked this question a lot. Like another version is like, how can we scale up, the benefits of jury decisions that I write about? And I think there's two aspects that can be transferred to other domains that are really important to have the kind of outcomes and experience of juries that I would like to see. The first is to have time for, let's say, citizens in a citizens panel, or to really understand the issue. Like, I think the immersive quality of being in a trial is very important for the kind of cognitive work of being a juror, and even the fact that you have to not be on your phone, during that time, right? That you have to fully focus your attention on this, and you also get a lot of information. So I think allowing citizens to go through something like that, potentially a multi-day workshop, or a space where they can really be immersed in a topic and hear about it from different perspectives and ask questions, I think is a key part of the decision-making process, as opposed to something like a survey or voting or things like that. I think something that's much more intense and deliberative on the front end is important. And I think the other key thing about what we can learn from juries in the legal system is that for them to be important, both for society and for the people that are on them, is that they have to have final decision-making power. Like, they can't just be an advisory committee to someone else, because that is frustrating for the people that go through it. And when you don't have final decision-making power, that intense experience that you've had, almost feels like an insult. Which is like, why did you make me sit here for this time if you're not going to take the advice that we, deliberated on? We came, I'm sure there were probably, heated debates, to get to what the recommendation was. And if you don't take it seriously, the whole thing, I think, it loses so much power if it's just an advisory board. But I think, like, in some places, participatory budgeting, does give lay people a final decision-making power, right? You have this amount of money, you guys decide how to spend it, and we will respect that. And I understand when people have like reactions against that, like, oh no, like, what if they spend it in a bad way? But like, we have reactions to that in so many other places too, with elected officials, with experts, right? And I think we just need to spread out this discretionary power such that we might have bad decisions from a citizens board, but that's okay. Like, the next year you'll have a different time, an opportunity to make a decision. And so I think that to bring the advantages of juries outside of the courtroom, it means to give ordinary people final decision-making power.
Right. Well, we will leave things there. Sonali Chakravarti, thank you so much for joining us today.
Thanks. It was a lot of fun.
So a lot of really interesting and provocative stuff there. I just want to start anyway with the argument that juries are not representative. And she makes a lot of points about that. And in terms of not having, it's not effectively constitutional insofar as it's often not a jury of one's peers. And, especially when you're talking about people of color. And I mean, I guess I would argue, and I'd be interested to hear what you say about this, Candace, but I would argue that there's nothing in the Constitution that says there needs to be any reason why someone is or is not selected into a jury pool. And so it doesn't have to be driver's license. It doesn't have to be voter rolls. My argument would be that voter rolls is not a bad way to select jurors, because people who are registered to vote have already demonstrated that they have an engagement with their society, with their democracy, and take their responsibilities seriously. And that's the kind of person that we want in the jury pool. So, I mean, if there's a problem there, then I'm not I would just argue that the place to address it is not in the jury pool. It's the place to address it is voter registration.
I think that there are a series of assumptions being made here that people who are registered to vote are already kind of demonstrating some sort of, civic responsibility or recognition that they need to be involved. But a couple of things. One, we know that people who are younger, more transient, are not going to be registered to vote because you have to register to vote every single time you move.
Mm-hmm.
Two, that is a suggestion that people who don't vote who might be doing that as their own political stance. And we can have a whole argument around whether that's a good thing to do or not a good thing to do, but that people are recognizing, are cognizant of the choices that they have and they don't want to engage. The third thing that comes to mind is a talk that I went to Kimberly Latrice Williams, who wrote a book called How We Can Win. She's also a YA writer, but she was a part of the team in the Ahmaud Arbery case. And by team, I mean, there were a lot of people involved in getting that case to national attention, to ensuring that the prosecutor was not a person who had ties to the murderers, so on and so forth. And one of the steps that she mentioned was that there was a get out the vote drive, but not for people to vote, but for people to get in the juror pool. And so people didn't vote because they were in a solidly red space. Why would they? They were never going to get what they wanted because we have districting that allows representatives to select their voters. So why would you register to vote if you know that you're never going to have an opportunity to select a representative of your choice? So I'm really glad that Sonali brought up these kind of different possibilities around residency, around taxes. I mean, if you pay your taxes, are you not also a responsible citizen?
Mm-hmm. Mm-hmm.
So, those are the things that come to mind about the shortcomings of using voter rolls and connecting voter rolls to jury selection. The other thing is that we also know that when you do that, you also have already said, if you cannot vote, you cannot be on a jury. And maybe people want to have different selection criteria of like, okay, well, maybe you can't vote, but maybe you can be on a jury, for example. So yeah, I just think it's more complicated than that.
I think it is also worth talking about. You said at one point that we're talking about the health of this all reflects on the health of our democracy. And my thought was, yeah, it really reflects on the health of our law, which is not completely the same, but obviously, overlaps significantly. But, when we are in a society where so few cases go to jury, it is almost like, yeah, you have this power, but you're probably not going to use it. And if you have these First Amendment or these Bill of Rights, the Sixth and Seventh Amendment, right to a jury trial, but this tiny percentage of people are actually going to have the opportunity to exercise that right, that is a problem. And to talk about how the jury fits into that is almost like talking about a tiny sliver when there's this big looming issue that is going unaddressed.
Oh, yeah, totally. So I think that what you're saying is that the fact that people do not go to trial is a symptom of a larger problem.
Yes.
Agreed.
Yeah.
Yeah. And I think, what you're pointing to is the health of our criminal legal system.
Mm-hmm.
People do not go to trial 95% of all, people would rather plead out, in part because they know the game at hand. They know that there is a person who, come hell or high water, needs a guilty verdict.
Mm-hmm.
because, and this goes back to our previous conversation, that is linked to their electoral
Yep.
well-being. And so, if you are a prosecutor who is motivated by being reelected by a very specific group of people, you're going to want to come down hard on all sorts of things just so you can say that you won and that you were tough on crime, et cetera, et cetera.
But also, at some point, we have to question whether or not this is legitimate in terms of a democracy and also in terms of, the objective of justice, right?
Mm-hmm.
But that raises another issue I wanted to mention, which is her big push for the right of the jury to at least reserve the right to nullification. When the jury feels like the law that is being applied is unjust, she wants to leave open, I think it's fair to say, she wants to leave open the possibility for the jurors to use their experience as, someone who lives in these communities and who sees the police in action, et cetera, to just decide the case in terms of justice and not in terms of law. And I went to the book. I don't know how much of this, I mean, I might have missed it, but my first thought was the place where there was the most jury nullification was in Jim Crow South, where people were guilty of, crimes against African Americans, and they got off because they had an all-white jury and didn't matter what the law was. And so the idea that we're going to advance this opportunity, particularly in a world, in a society right now that is so polarized and where the rule of law is threatened to a degree that it has not been in a while, I don't think that's a good idea. I think I would much rather have, Tocqueville's idea that, what juries are being schooled in is the importance of the rule of law and the importance of striving for an objective application of the law. Justice is blind, all that. I feel like that is what we should be looking for in juries, especially at this moment.
So Sonali is not innovating here. She is just saying that this possibility exists and it always has existed. And we should probably know that this is a thing that a jury can do. There are several cases of which jurors did not know fully what their choices were. And they gave bad choices because they thought that they had to choose within a particular set of constraints. And turns out that the instruction was not clear or wrong, and they end up doing something wrong. So, and things that they wish they could have done, they wish they could have done differently if they knew that they had a different choice, right? Okay, why am I saying this? I'm saying this because what I think that Sonali is pointing to is that there are points in time, moments in history, laws on the books that are unjust. And nobody can really, not nobody, because there are plenty of people who think that the way that the world works is just fine. That there is actually another possibility that maybe jurors, people, Americans might feel more empowered if they knew that there actually was a different possibility, another choice. Now, whether they actually lean into that, that's a totally different thing. But to know that, what if I walked in here and I found that it just was like really bad, that, I know maybe there's a possibility of a different outcome. But most people, as we see, stay within the bounds. So my sense is that what she's really calling for is a broader knowledge base for Americans to know what is possible. of being a juror. The other thing I think that comes to mind, and she says this herself, is that there is a split between morality and legality. There are a lot of things that are perfectly legal that are wrong.
Sure.
That's how we have so many police problems, for example. And the case that she cares about right now is abortion and prosecuting people who help others to get what is otherwise a safe procedure, and in some cases, safer to do that than to continue on with the pregnancy. So, my sense is I hear you. I hear where you're coming from, that the rule of law is being threatened, that there's so much polarization, that what if people did lean into this more? Then we would just be willy-nilly all over the place. But we also have to consider that that these things have to happen in a group, right? The examples that she gives are the jury as a body was, decided, no, we're not doing this. It wasn't that one person went willy-nilly and decided to disrupt the entire process.
I think the fact that we've had this kind of conversation just speaks to the importance of this book and speaks to the fact that she is absolutely right that we have neglected the idea of the jury as a manifestation of enfranchisement and empowerment among the citizenry. And we, people who care about democracy, need to think about this in terms of how we practice law and how our justice system operates. So kudos to her. So for Democracy Works, I'm Chris Beam.
I'm Candace Watts-Smith. Thanks for listening.
Democracy Works is a collaboration between the McCourtney Institute for Democracy at Penn State and WPSU Public Media. Our editors are Michael Klein, Chris Kugler, Mark Stitzer, and Clint Yoder. Editorial review by Emily Reddy. Additional production support from Andy Grant and Christine Allen. If you enjoyed this episode, please leave us a rating or review in Apple Podcasts, Spotify, or wherever you're listening right now. Democracy Works is a member of the Democracy Group Podcast Network. Visit democracygroup.org to learn more about our podcast collective devoted to democracy, civic engagement, and civil discourse. Thanks for listening. We'll see you next week.